Hello everyone, welcome again to my channel where we focus on empowerment, lifestyle and finance. My name is Debbie Olabisi. I'm a specialist protection advisor, a speaker and an author. Today we're going to be talking about lost wills. I encourage you to go to our channel and look at all the videos we have posted previously to bring yourself up to speed with the issues I have discussed. Like I said earlier, today I'm going to be talking about lost wills. We've talked about wills, we've talked about revoking wills and some other topics on wills. So look through our channel and bring yourself up to speed. Now, if it is the case that a will cannot be found by family members after death, it is possible for a copy of the will to be submitted to probate. However, this may not always be the case. There are hurdles that must first be overcome. Today's topic will cover problems that can occur with lost wills and advice that I will give to my clients. So what are kind of problems that can occur? If a will is lost and the last known location of the will was in the testator's possession, a presumption arises that the testator has destroyed the will and with the intention of revoking it. This presumption is rebuttable by showing enough evidence of non-revocation. The exact amount of evidence required will vary from case to case, as the strength of the presumption of revocation varies depending on the level of security or lack of it of the testator's custody of the will. The safer the testator held the will, the stronger the presumption. For example, a person who keeps meticulously neat files, there will be a strong presumption that they destroyed the will, as such a person could not easily mislay a will. Evidence used to rebut the presumption varies, but can include statements made shortly before death that are inconsistent with having destroyed the will, and that the will was made so recently before their death, along there being no evidence to suggest that the testator had changed their mind. A leading example of a lost will is Surgeon versus Lord St. Leonard's, which concerned a former Lord Chancellor in the 1800s. The testator kept his will along with 8 codicils in a locked box. There was a spare key to this box that was not kept securely. Upon opening the box after his death, the codicils were found, but the will was missing. It was held that the presumption of destruction was rebutted, as no former lawyer would have destroyed their own will without also not destroying the codicils and writing a further will. Another problem that could happen with lost wills is the process of obtaining probate of a lost will. Where the original will is lost, it may be possible to obtain probate of a draft, copy, or possibly even an oral reconstruction of the will. An application for an order under Rule 54 of the Non-Contentious Probate Rules 1987 will need to be made. Evidence to show the terms of the will, that the will was duly executed and the will hasn't been revoked, will need to be provided. Family members will also need to seek advice from probate professionals at this point. Advice to clients. With all wills produced by us, we also produce a remote attestation record that should be signed in the same way as the will. We strongly advise that these are completed and returned to us for our files. In the event of a lost will, the remote attestation record can be used as evidence to show that the will was executed validly. We also advise professional storage, such as that we provide with the National Will Archive. This is highly advisable to avoid risks of the will being lost. Furthermore, in the unlikely event that a professional storage company lost the will, the presumption of destruction does not arise, as the last known location of the will was not in the testator's possession. Wherever a client decides to store their will, they should be advised, I'm advising, that you let your executors know where a will is stored. This will ensure that the will can easily be found when the client has died. Otherwise, the proposed executors and beneficiaries may not be able to find the will. This may mean that they may decide that the will is lost and instead rely on the terms of intestacy or an old will that they are unaware has been revoked. Furthermore, I would advise my clients that they should also consider registering the location of their will through another company called Certainty to ensure that their executors and beneficiaries can find it. As a will writing company, I often get letters from other companies, for example, will finders. Somebody has passed on a year, 2, 3 years, and they write will writers in the area seeking to see if they had their will. And it's so sad that if somebody took the pains to write a will, that at the point of death, the family cannot find the will. So my regular advice is always keep the will in a safe place. Let your executors know where your will is being stored, and the best of all is to have it stored with a company such as the services we provide with the National Will Archive. Thank you for watching this video today. I hope I've been able to explain to you clearly what can happen when a will is lost and the testator has passed on. If you enjoyed my video, please, I would appreciate you to post your comments, questions, and also to share and click the the subscribe button, so that anytime I post videos, you will be notified and you will not miss any of our videos. Thank you so much for watching, and see you next time. Bye.